Mr. Kavanaugh?
Wasn't quite sure of your answer to Justice Jackson. If Catholic Charities ran an orphanage or a home for the aged, what result?
I think it would be treated like their current ministries, like a housing ministry or other things. So I think that language in the legislative history, to the extent that it then got transposed into Wisconsin law, and was seen to say, orphanages are out. I think that would be a problem, because there's nothing in the law itself that says that, the text of the law that says that you can't have an orphanage.
So to the extent that reflected an understanding at the time, that understanding is simply inconsistent with the statutory language. Is that the answer?
Yeah, I think the answer is just that statutorily, I think that would be very hard to do. And I think, as I was trying to make out earlier, that there's a constitutional avoidance problem there too. If you create these sets of approved religious, judicially approved religious activities, that's a real problem. This court has identified them in cases like Hosanna Tabor or Our Lady of Guadalupe, but it was very clear not to say that that's a closed set. It's an open set, and that other kinds of activities or things might be in there. Obviously, ministerial exceptions a little bit different, because it's talking about these important religious functions within the body, but religious. The set should not be closed by the judges. The judges should not close it.
And I think your answer is getting at another question I have is, the other side relies on the phrase distinctively religious activities. I just want to make sure you can respond to the use of that phrase.
Yeah, I think it's, 6 of one, half dozen of the other. If you look at the opinion below, they consistently talk about it's wholly secular endeavor, it's not religious in nature, it's secular in nature, and then they rely repeatedly on the list from the Dykema case from the Seventh Circuit in the 80s, and, they've come up with a little list, and they're saying that this is the closed list, and we're outside the list. Whatever, they say, oh, it's just an illustrative list in the opinion, but we're still out. What we're doing clearly is not on the list. Whatever other things might go on the Wisconsin Supreme Court's list, we're not on that list. Helping the poor, helping the elderly is not on the list.
And the limit on that, to go to the other side, is what again? Sincerity is one limit.
I would say.
What else? Is there any other limit to the Chief
I would
Justice?
say that's probably the main limit. Is it sincere?
Is it the only limit?
Well, I would say also religiosity, but in the sense of religion versus philosophy. So this is the thing that actually comes up in the Yoder case, where the court makes a big distinction between what the Amish were doing and what Henry David Thoreau was doing. And it said, well, there's special solicitude under the First Amendment for religion, and the Amish get that, but Thoreau doesn't, even though he felt very strongly about his opinions.
Thank you.